And we are back. This is Section 2, Part 1 Theory, The Truth About Esquires from Cracking the Code 3rd edition. Next section, The Fox Guards the Hen House. Besides the fact that all three branches of what passes for government in America, the legislative, judicial, and executive branches of bankrupt de facto U.S. Incorporated, are run almost exclusively by personnel operating under a British title of nobility. Every prosecuting attorney at every level of government operates in a manner that makes a mockery of the separation of powers doctrine. Under Attorney and Client in Corpus Juris Secundum, 1980, we have quote, his first duty is to the courts and the public, not to the client, and wherever the duties of his client conflict with those he owes as an officer of the court in the administration of the justice, the former must yield to the latter. The office of attorney is vital to the well-being of the court. Attorneys, as officers of the court, have duty to maintain respect due court, which duty should exceed that imposed upon the public generally, and which duty should not be looked upon lightly, and cannot be shirked under the guise of representing interests of the party litigant. So 7 Corpus Juris Secundum 4. There's another quote. Duty of attorney is to court if litigant's client's interest threatens a state interest. Corpus Juris Secundum 43. One who is admitted to practice as attorney at law, both by virtue of his oath of office and customs and traditions of the legal profession, owes to the court the highest duty of fidelity. 7 Corpus Juris Secundum 4. Quote, it is generally accepted that an attorney is an officer of the court, and as such, an officer and arm of the state. 7 Corpus Juris Secundum. That's Virgin Islands Bar Association versus Dench. There's that reference there. The internal memo from the executive director of the State Bar of California referenced earlier is in complete harmony with the above cites from Corpus Juris Secundum. The State Bar of California is a constitutional agency in the judicial branch of state government, and the purpose of the State Bar is to act as the administrative arm of the California Supreme Court in matters relating to the regulation of the legal profession. As abundantly shown above, the duties and obligations of Bar Association attorneys lie with the court and with the public or governmental interests, and never the client. Clients are fodder for the wealth confiscation and freedom usurpation activities of the court. Attorneys are elevated above others with a special property right and title of nobility, and empowered with quasi-immunity to ensure that the courts get their daily ration of code-ignorant customers. Prosecuting attorneys are, by definition, part of the executive branch, but because all the attorneys are officers of the court and members of the judicial branch, prosecutors must first genuflect for the judge for his or her lifeline in the marketplace, and second for the executive branch, which issues his or her paycheck. So genuflect, to bend the knee as an act of reverence or worship. Okay, it's a weird word. While the Attorney General is part of the executive branch of government as an attorney, he is also an officer of this court. When he appears in court in a legal matter, he is acting as an attorney. This factor conserves the most egregious conflict of interest in government today, in that a prosecuting attorney's first duty is drumming up business for the court or judicial branch, the private enterprise enforcing polity of British corporations. This arrangement is a self-initiating business monopoly operating under the charade of government altruism, where the prosecuting attorney's actual agenda is pleasing the judge, and the judge's foreign masters are bringing in sacrificial client victims from the enemy camp. It's from Main Street, USA. Not in standing guard as a sentinel of freedom, as a member of the executive branch, and ensuring that justice prevails. Interesting. Separation of powers doctrine. This philosophy manifests for non-prosecuting attorneys as well. At a 1999 private get-together, a junior of LA's former city attorney, Gil Garcetti, revealed in conversation with an associate of your author's that his primary duty was third in command at the city attorney's office was generating new business for attorneys. The judicial system is a private business monopoly posing as an agency of government that dispenses justice and preserves and upholds the U.S. Constitution. Upon investigation, its actual agenda is found to be herding unwary and unwitting victims into court for sacrifice at the judicial altar. The judge-attorney brotherhood deals in secret clubhouse, members-only code words, language, and procedure specially formulated to ensure that non-insiders do not comprehend what is transpiring. There is an almost infinite number of legal trapdoors, escape hatches, and secret diversionary techniques used for shunting knowledgeable customers when they get too close with the workings of the operation. The original unenacted 13th article of amendment of the Constitution reads as follows. All right, the 13th Amendment should have been this. If any citizen in the United States shall accept, claim, receive, or retain any title of nobility or honor, or shall, without consent of Congress, accept and retain any present, pension, office, or emolument of any kind whatever, from any emperor, king, prince, or foreign power, such person shall cease to be a citizen of the United States and shall be incapable of holding any office of trust or profit under them, or either of them. Interesting. So that's should have been 13th Amendment. Okay, so the entire purpose of the Crown's or England's War of 1812 in America, despite having signed the Paris Peace Treaty only 29 years earlier, was the destruction of the official records containing the first 12 states' approval of the new Article of Amendment, housed in the Library of Congress. Ratification by 3/4 of the 17 states was necessary before the amendment could be enacted, and Virginia was the only state that had not voted. The so-called War of 1812 was initiated before this could occur, although Virginia later passed the amendment as proposed. Once the building and its contents were destroyed by fire, the war was over. The British withdrew, and the members of Congress were pressured in various ways to retain only extant prohibitions in the Constitution, which state merely that the U.S. government cannot grant a title of nobility and that the consent of the Congress is required to accept any such title. The money changers overseeing the Crown thereby arranged for the continuing unfettered commercial conquest of America by stacking all three branches of government with de facto British military officers. Had the Library of Congress not been destroyed, we would have no British agents or esquires or attorneys holding political office in America, and no 14th Amendment, no U.S. incorporation in 1871, no 16th Amendment, no Federal Reserve Act, no U.S. bankruptcy in 1933, no personal income tax, now over $22 trillion national debt, and no Social Security Ponzi scheme and numerous other social, economic, political calamities, all handiwork of the king's esquires. Next section, sugarcoating the deceit. The reason Hollywood cranks out so many feel-good lawyer movies where the selfless, kind-hearted, benevolent attorney is played by a box office superstar, the reason there are so many attractive, popular actors and an ever-increasing number of engaging courtroom, judge, and attorney-related TV shows, the reason all judges carry a quasi-title of nobility, that is something like the Honorable Judge. The reason the media carries on the charade disguising the true nature of the bar associations and the phony license to practice, etc., is to obliterate the truth and persuade the masses via continuous bombardment with subliminal messages that judges and attorneys are a swell bunch of patriotic guys and gals who take up for the little guy and work tirelessly for truth, justice, and the American way. Such propaganda gushes forth with increasing frequency as required damage control for the devastating societal impact of the wholesale destruction of lives at the hands of Esquires. The entire operation is predicated on keeping victim customers ignorant of the meaning of the secret code words and the rituals employed in the process, an unfeeling, cold-blooded reptilian mentality. The life of an esquire, i.e. all bench officers and all attorneys, is an ultra-deceitful, quasi-genocidal undertaking in charlatanism, where a successful career is determined by the esquire's efficiency in separating the esquire's clients and sometimes even adversaries of the esquire's clients from their wealth and freedom. Esquires deserve no sympathy from anyone because they play by a different set of rules than everyone else. Attorneys win only 50% of their cases, a mathematical factor, but a moot point because attorneys always get paid win or lose. Whereas other professions are paid based strictly on results and the quality of their work, attorneys collect their inflated fees in full even when they fail, and payment of attorney fees is enforced by the judicial system. Conclusive proof of the inherent criminal nature of the U.S. judicial system and all its collaborators. After all, what is a criminal but someone in possession of a valuable commodity that was acquired without exchanging something else of value for it? Yep. Half of all fees collected by attorneys are obtained without fair exchange, not much different than extortion, ransom, and solicitation of bribes. The true nature of the legal brotherhood gets clearer and clearer. The judicial system enforces payment of legal fees by judicial decree, even when the attorney fails, so the attorney community will continue bringing business into the court. What other profession gets paid in full for complete failure? Here we go, next section. Money motivation. When the Fair Debt Collection Practice Act, FDCPA, was enacted on September 20th, 1977, Public Law 95-109, the Act exempted its provisions any attorney collecting a debt as an attorney on behalf of and in the name of a client, seizing on the obvious advantage a debt collector could not threaten legal action, for example, but an exempted attorney could. The number of attorneys handling consumer collection accounts quickly surpassed the total number of lay collectors in the entire industry. Representatives of a major national firm testifying in a hearing before the subcommittee of the U.S. Senate on May 25, 1983, estimated that in 1982 alone it received 365,471 consumer accounts for collection. This is representing a total dollar value of more than $355 million, roughly 10 times the volume collected by the average American Collectors Association member agency as determined by a national survey. This law firm also testified that nearly 92% of the consumer collection accounts it handled that year did not involve legal action, i.e., no lawsuit was necessary for 92% of the money it collected. Quoting from the House Report 99-405 in 1986, from which the above is taken, quote, the application of several provisions of the Act to attorneys collecting debts are worthy of note. The restrictions of Sections 804 and 805B on contacts with third parties, neighbors, employers regarding a consumer's debt are intended to protect the privacy of consumers' financial affairs. These contacts are not legitimate collection practices and result in serious invasions of privacy as well as the loss of jobs. The committee discerns no reason to make any distinction based upon the identity of the debt collector, besides threatening the entire lay collection industry with extinction within 5 years of inception of the FDCPA. The practices of debt collecting Esquires generated so much enmity in American consumer voters that Congress was besieged with demand for help and in 1986 officially removed the attorney exemption as cited in the House report. The original basis for the exemption was a belief that the State Bar Association would adequately police attorney violations, but the evidence revealed a different scenario. The main concern of state and local bar associations is not the protection of consumers, but the protection of lawyers. Unquote. Despite their setback with the FDCPA, attorneys still have a license for subterfuge, deception, and thievery courtesy of the monopoly over the field of law held by the bench officers, another coven of Esquires. When you begin doing asset searches on judges and government attorneys, the magnitude of the con begins to come into focus. Many of these characters are fabulously wealthy, and a great many of them, especially judges, have transferred title of all property from their name into the name of a trust. The potential of getting nailed under their own name for misdeeds, crimes committed against any unending stream of unhappy customers is certainly enough reason to take such measures. Esquires are motivated by money, the lowest form of motivation, proven by the very nature of their profession, an exclusive cult with foreign allegiances whose members thrive on withholding vital information for clients, adversaries, and other marks intended victims in a confidence game, and who will casually and callously trash the life of anyone for the sake of personal financial gain, depending utterly on the ignorance of victim clients to perpetuate and con the stay in business. Based on first-hand knowledge and experience, the loftier the position, the more perfidious the Esquire. Next section, Government Esquire Debt Collectors. Even though regular attorneys must comply with the FDCPA in the collection of a debt, government Esquire debt collectors do not. Government officials, i.e. U.S. attorneys and assistant U.S. attorneys, are exempted from the Act and labor under no such restraints in conducting business. As mentioned earlier, all crime is commercial. 27 Code of Federal Regulations, Section 7211, with a commercial financial charge attached therewith, and any occupational demand for money is classified as debt collection. Government debt collecting Esquires bring in tremendous sums of cash for themselves and their masters, hindered by the restrictions of the FDCPA. A revealing related fact concerning debt collection personnel at IRS. While government officials are expressly exempted from the FDCPA, IRS officials are not. Section 5.1.16. 01 looks like January 24th, 2001 of the Internal Revenue Manual reads as follows. Quote, under this section, Fair Debt Collection Practices Act. So IRC 6304 requires the IRS to comply with certain sections of the Fair Debt Collection Practices Act. These deal with contacts regarding unpaid tax and harassment and abuse of taxpayers. The law applies to contacts with all taxpayers, including corporations and partnerships. If IRS were an agency of the U.S. government, there would be no mention of the FDCPA in its manuals. IRS is not part of the government, so IRS esquires are bound by the restraints of the FDCPA, just like all other non-governmental debt collectors. Next section, military courtrooms. The law of the flag tells us that the colors of the flag flown in any forum on any vessel dictates the law form and jurisdiction under which that entity is conducting business. Original legislation describing the American flag is found at Title IV United States Code, Chapter 1, Section 1, 2, and 3. Flags are not meeting these exact specifications are expressly excluded as American flags. The flag that flies in today's courtrooms is not the American flag described in Title IV, but rather a gold-fringed military flag of war enforcing the private general equity admiralty maritime law of the same merchant bankers and shippers who swindled Americans' gold and bankrupted and conquered the U.S. government between 1907, the money panic of 1907, and 1933, depletion of gold stocks and repudiation of obligations, that is to say, could not make good on promise for redeeming gold certificates, equaling insolvency and bankruptcy. Placing of fringe on the national flag, the dimensions of the flag and arrangement of the stars are matter of detail not controlled by statute, but within the discretion of the President as Commander-in-Chief of the Army and Navy. Okay, there's that little quote there. Next, American courtrooms are stacked with foreign military personnel esquires in quest of military objective mission statement of the Bar Association doing battle with enemies, debtors of the crown, creditors, and extracting war reparations, war contributions, and taxes from belligerents, that's the American sureties, in the field or battlegrounds and colonies. So by law, any courtroom flying a military flag is a military courtroom tribunal under martial law rule. Admiralty is a unique jurisdiction in that it carries criminal penalties for civil offenses. The only jurisdiction where military might is employed is enforce private contracts. Okay. So you got criminal penalties for civil offenses, and this jurisdiction is employed to enforce private contracts. Under martial law, the accused is guilty until proven innocent, and a judge rules summarily in an administrative proceeding without a jury, as is done in traffic and misdemeanor cases in America. In such matters, the customer has two choices. Number one, appear before a bench officer and attempt to prove himself innocent. Number 2, simply concede guilt and mail in the payment. Failure to convene a jury for felons and certain other circumstances can make for too much bad publicity, and so is avoided. Next section, conquest through commerce. You may have wondered why China is on the mind of so many American politicians, and why actors within the U.S. government have been such vocal and legislative champions of China's cause in obtaining most favored nations trading status and being allowed admittance into World Trade Organizations, WTO. China, which represents the largest source of cheap labor in the world, China can undercut Mexican labor by as much as 90%, was bankrupted in 1933 along with America and every other noteworthy government at the time, and was thereafter converted into a communist state in 1949. The mother lode of manpower has now been successfully harnessed for dominating by outproducing and undercutting the labor force of every nation in existence, a planetary economic free-for-all that quietly began in China's entrance into the World Trade Organization. Okay, let's read this real quick. 52. A distinction exists between martial law rule and martial law. Martial law rule has been the normal operating condition in America since 1861, when rulership devolved into the hands of the President of the United States, in his capacity as Commander-in-Chief of the military. Okay, now martial law, as opposed to martial law rule. Martial law, on the other hand, is a state of express, undisguised military rule, with troops in the street and the military serving as police, governing all civilians' function. Americans will know that their country is officially under full-fledged martial law if the President, in a televised address from the Oval Office, ever has a red-fringed flag displayed behind or by his desk. Okay, so you're looking for the red-fringed flag behind the President's desk for martial law. The inevitable denouement of the clandestine love affair between Beltway commies and Chinese labor is portended nowhere more clearly than in the article from January 27, 2002 edition of the LA Times, Cranes Lift Upstart Above Competition, page C1. Quote, San Francisco, beneath autumn skies, a freighter carrying 4 of the largest container cargo cranes glided into San Francisco Bay, squeezing under the Golden Gate Bridge en route to docks of Oakland. That day in the fall of 2000 was a spectacular but not singular triumph for an upstart Chinese company that dominates manufacturing of the most important piece of maritime machinery other than ships. The story of ZPMC's Shanghai Zhenhua Port Machinery Co. Zhenhua Port Machinery Co. Companies. Okay, the story of ZPMC's rise illustrates the gathering and at times controversial economic might of China as it dominates new sectors of global commerce. Quote, after being launched in 1992, ZPMC took just 6 years to become the leading maker of ship-to-shore cranes, and the company has remained at and near the top. In U.S. ports, where the company sold dozens of towering cranes for $5 million to $7 million, the formula for success was simple: bid low and build alliances. Using its own Chinese labor and its own fleet of delivery ships to cut costs, ZPMC consistently underbid the competition by hundreds of thousands of dollars or more. China's role in the chosen master's attempted conquest of Earth is that the great equalizer, i.e., the commercial force of amalgamates all competition in a homogeneous mass of ineffectual workers and consumers, and the banker frontman in District of Columbia has spread no further to ensure China's needs receive top priority. Did you ever ask yourself how China and Russia ended up on the UN Security Council at its inception? Business as usual for the same gang that conceived, beginning in 1931 in New York City. Organized finance precipitated, orchestrated, and dictated strategy and tactics for United Nations Coming Out Party, World War II. Article 1, Section 10, Clause 6 of the Constitution says, no state shall pass any law impairing the obligation of contracts. Because treaties are voluntarily entered into international contracts, and the obligation of contracts is inviolate, treaties take precedence over the Constitution by default, and we are hopelessly mired in the entanglements of the political, military, ecological obligations of the DC-based executive superstructure has decided to put is good for us, i.e., the enforcement of the wills of its masters, the owners of the Federal Reserve note. The global political landscape is changing, and it doesn't have as much to do with national boundaries as it does with the most common medium of exchange. Anywhere in the world you find Federal Reserve notes changing hands, you will also find IRS. Why? IRS is a private, Puerto Rico-based intelligence gathering, accounting, and collection agency responsible for policing the travels of every single Federal Reserve note in existence and penalizing and fining anyone that comes in contact with one of these things. If such an unwitting recipient does not carry a U.S. passport, no problem. Virtually every government on earth is bankrupt to the same bankers. So there is not too much concern about where the tax is collected. It all ends up in the coffers of the owners of the banking system. An indispensable tool of the chosen masters, next section. A major turning point in the history of civilizations was a gory, one-sided battle of Hastings in 1066 AD, wherein a tranquil English society was forever transformed by an invasion of barbarians under the tyrant William, Duke of Normandy, William the Conqueror, also known, a pawn of the chosen masters. The most significant aspects of the conquest were those in the field of law. The first one being Anglo-Saxons were stripped of rights and privileges they had enjoyed for 300 years. The second, an effective dictatorship was established with William collectivizing the executive, legislative, and judicial branches of government under his solitary control. And number three, lastly, but possibly the most detrimental long-term consequences of all, but the introduction of Norman French attorneys who brought with them a new language that destabilized the fabric of society and made legal mincemeat of the defenseless Englishmen unlearned in the new French dialect. So, quote, law French. The corrupted form of the Norman French language that arose in England in the centuries after William the Conqueror invaded England in 1066, and that was used for several centuries as the primary language of English legal system, Black's 7th edition. All the foregoing classic tactics and stratagem of the legal masters of the world a modus operandi that reappeared in America. Quote, "The land of the free and the home of the brave has more people in prison per capita than any other country. Former rights and privileges are now crimes." Let's read this real quick. FYI, there are 3 particular items that can be traded, bought and sold, only in Federal Reserve notes: gold, oil, and medium-term notes. Medium-term notes are euro dollars denominated bank debentures, obligations issued in face value amounts of 10s, 25s, 50s, and 100 million US dollars with 1 year and 10 tenors. 58. More evidence that the IRS is part of the federal or a foreign military occupation of the de jure states of the Union under Secretary of the Treasury, the Commissioner of Internal Revenue, both domiciled in Puerto Rico, is an affidavit signed by Russell K. Stewart upon his appointment as IRS attorney. This affidavit may be seen as appendix under IRS appointments of parent communists as attorney. In his standard appointment affidavit for securing employment as an IRS attorney, Stewart lined or deleted portion of the affidavit stating that he was neither a subversive nor a communist nor a fascist, and that he was not a member of any organization that advocates the overthrow of the constitutional form of government of the United States. The crossed out segments comprised approximately 50% of the affidavit. Stewart appears to be a subversive communist fascist and also appears to advocate overthrow of the American constitutional form of government, but IRS doesn't have a problem with that. What is the purpose of the affidavit if need not be sworn to? How many other IRS attorneys share Stewart's philosophy? All right, 59. A possible source of inspiration for Shakespeare's famous line, "The first thing we do, let's kill all the lawyers." Okay, that comes from Shakespeare's The Second Part of King Henry VI, Act 4, Scene 2. Stratagem. A maneuver designed to deceive or outwit an enemy in war, a deceptive scheme for obtaining an advantage. All right, here we go. Continuing on. Courtesy of the Trading with the Enemy Act of October 6, 1917, as amended, and emergency wars power. There's all your references there. The President retains supreme dictatorial power over all aspects of American life and government, like William, as Commander-in-Chief of the military. For example, no congressional approval needed for war. All courtrooms in America flying the gold French flags of war are military tribunals under the President's direct control, complete power over all commerce, transportation, agriculture, communication, etc. And, final point, it is the foreign language of attorneys who speak in Latin and the encrypted codes, the stock in trade of Esquires, that keep them elevated above the sheep that must be shorn. All right, next section. Founding Fathers Esquires. A glaring and alarming historical fact is that the Paris Peace Treaties of 1783 between Great Britain and the United States of America was negotiated on America's behalf by 3 prominent King Esquires, Ben Franklin, John Jay, and John Adams, and each is so identified in the treaty. For example, John J. Esquire. Curiously, Franklin, the principal negotiator, spent most of his time during the war years traveling between England and France, where George ruled as king simultaneously over both and Ireland as well. Despite apparently having just been defeated in war, it was King George, not Congress, who convened the Treaty of Peace. He was represented by another officer of the Crown, David Hartley, Esquire. Since America supposedly won the war, thereby becoming Great Britain's international equal, it is illogical that we would afterwards seek rights granted by King George at the Treaty of Peace. How could George be in any position for granting America anything in the treaty, such as its own land, the land that he supposedly had just officially lost control of and relinquished via military defeat? Why would America's negotiators enter a contract that would effectually nullify the sovereignty we had just achieved? So we won the war through military defeat, but then lost it through paperwork? The treaty was signed neither on the soil of the apparent victor, America, nor the apparent loser, Great Britain, but in a third jurisdiction, France, who decided upon by King George. If we won the war, why were we incapable of dictating the terms of a treaty with a vanquished former foe from a position of strength? The Jay Treaty of 1796, authored by one of the same negotiating esquires, John Jay, also confirms the dubious nature of the outcome of the war. Whereas the king promises hasty withdrawal of his armies, garrisons, and fleets in the peace treaty of 1783, we find that his forces are still in place 13 years later. Quote from the Paris Peace Treaty, Article 7, "There shall be a firm and perpetual peace between this Britannic Majesty and the said states, and his Britannic Majesty shall with all convenient speed withdraw all his armies, garrisons, and fleets from the said United States, and from every post, place, and harbor within the same." The Jay Treaty, Article 2, "His Majesty will withdraw all his troops and garrisons from all posts and places within the boundary lines assigned by the Treaty of Peace to the United States." The Jay Treaty also reveals who holds the upper hand in finance and commerce, requiring the U.S. government to repay certain debt owed British merchants by American civilians. This is Article 6. Prohibiting trade of molasses, sugar, coffee, cocoa, and cotton with any country in the world other than Great Britain. This is Article 12. The outlawing trade of numerous items easily construed as war contraband with any enemy of Great Britain. And that's from Article 18. An independent confirmation of the United States of America inferior negotiating status is contained in an excerpt of the 1795 Supreme Court case, Penhallow versus Duane's Administrators. And there's your court case. Quote, "On the 14th January 1779, Congress resolved that they would not conclude a truce or treaty with Great Britain without the consent of France. The plausibility of a different practical outcome of the Revolutionary War, at least commercially, cannot be denied. That the American negotiators of the Treaty of Peace legally identify themselves as officers of the Crown holding a British title of nobility alone should excite a thorough investigation." Next section, world domination through deceit. The tradition of deceit and treachery has not faded with time, and the importance of the role of the Norman French attorney king's esquires in the ongoing subjugation of mankind cannot be exaggerated. Corporations, artificial creatures of the state operating under statutory law, are under exclusive control of attorneys who have the final word in all corporate activity and legal matters. Flesh and blood men and women, on the other hand, speak and act for themselves under the common law. However, based on the duplicitous use of people's name, corrupted in a corporately colored and all capital letter format, judges and attorneys have justified proceeding against trusting unwary victims as though they were a corporation, and have convinced virtually all Americans and the bulk of the rest of mankind by specious behavior, deliberate omission of the truth, and official insistence upon contrived falsehoods that they require an attorney, are bound by the same codes and statutes as corporations, and are therefore no different than an inert, abstract corporation or a slave of the state. John Quincy Public, naively believing that the Honorable Judas Esquire would never mislead him, now dutifully seeks an attorney in virtually all legal matters, voluntarily cementing his enslavement as a ward of the court and a person of unsound mind. The conceding is that he is incapable of speaking and acting for himself without such trickery enforced by underlying esquire judges and attorneys in the judicial system. The chosen masters could not prevail. Next section. Masters of Commerce and Law. The covenant intent on subjugating all of mankind began as but a tiny cabal, actually an elite hate group within a racist cult, determined to swindle all property on earth from all non-group members and rule the world from on high as the chosen masters. They got their initial foothold in the global commercial arena as shippers on the high seas in the Hanseatic League, cutting their teeth on the negotiable instruments law, NIL. That particular form of law, Admiralty Maritime, or General Equity, was brought ashore in this country in 1851 with the Limited Liability Insurance Act, and is now codified as the Uniform Commercial Code. Oh, interesting. The Limited Liability Insurance Act is now codified as the Uniform Commercial Code. All meaningful commercial paper falls under the headings of document of title and the negotiable instrument, both of which are jealous subjects of the Uniform Commercial Code. Incredibly, both of the negotiable instruments law and the Uniform Commercial Code are derived from the same voluminous, archaic, cultic, and cryptic hate manifesto, with its intricate teachings on property rights, authored by the self-same progenitors of the antisocial policies that we, as outsiders, must contend with in a myriad of forms every day of our life for our very existence. People have been converted into unwitting de facto merchants trading in worthless fiat money, Federal Reserve script, and many have become obsessed by necessity with such hollow, life-diminishing objectives as getting out of debt, making rent, and paying the bills, to the exclusion of a gracious, benevolent, aesthetic lifestyle, and everything else in between. Beginning with the French Revolution, this little coterie of malefactors has been the source of all revolution, insurrection, and global warfare amongst otherwise rational people and nations, and whose express purpose is open rebellion against all existing social order, and amidst the ensuing turbulence, introducing a new order customized for serving the needs of the instigators of the chaos. Let's read this little definitions real quick. Insights. Cabal, from the Hebrew Kabbalah, a system of esoteric philosophy developed by rabbis, reaching its peak in the Middle Ages and based on a mystical method of interpreting the scriptures. A number of persons, so cabal is also a number of persons secretly united for some private purpose. So that's the Standard College Dictionary in 1947. It has been said, and rightfully so, that virtually all crimes may be classified as hate crimes because most must, by definition, involve the element of hate. Hate crime legislation has been trumpeted in under the banner of numerous fronts, guises, causes, but the very origin of the concept of the ultimate objective is its proliferation for the providing legalized protection for the preeminent perpetrators of hate crimes in the world. The primary difference from this and lesser hate groups is that this one has access to unlimited finance and can wreak chaos on as much grander scales, too far immense in scope. World War for most folks in to conceive of this orchestrated hate crime. Apparently the culprits conceive that they need protection from those who might retaliate after discovering the vicious, inhuman, genocidal tactic that they systematically wreak against all non-cult members. Besides dictating over Esquire politicians that vote in such legislation, as reported in the LA Times, a non-political figure within its hate group even helped write the first hate crime statute. Members of this elite hate group think nothing of sacrificing significant numbers of their own kind, lesser uninitiated members, not part of their inner circle of cult, with no awareness of the workings at the top, for the purposes of proving that the cult has been victimized and been blaming other non-cult actors for the deed. The reported in the LA Times cult members have been caught red-handed by police in the commission of a hate crime of vandalism against their own cult and have openly confessed to the crime. Once wholesale numbers of people begin figuring out what is going on and organize, the chosen masters will need every form of societal insulation, legal indemnification, and hate crime legislation available just to stay alive, so they apparently believe. The speed with which information can broadly disseminate over the internet is a terrifying aspect of modern life. For this, the supreme hate group of all hate groups in history, the Hanseatic League, OHG, Hansa Military Troop, Band, Company, MHG, Hans, Fellowship, Association, Merchants, Guild, a medieval confederacy of German cities and German merchant settlements in other countries that was organized for the protection of their commercial interests. The origins of the association, which is also called the Hans or Hansa, are to be found in the West German cities to organize and control trade in the Baltic in the 12th century. A code of maritime laws known as the Laws of the Hansa Town, or the Ordinances of Hanseatic Towns, was first published in German in Lubeck in 1597. In an assembly of deputies from the several towns held in Lubeck, these laws are afterwards, May 23, 1614, revised and enlarged. The Encyclopedia Americana. Coterie, an intimate, often exclusive group of persons with a common interest. Okay. All right, continuing on. The advent of imitation money called credit, along with the most infinite number of permutations of such pretend money that have emerged therefrom, as well as a host of mutant institutions that have appeared solely for trafficking such currency, for example, the rigged stock and bond markets, insurance companies, etc., is the high watermark of the legacy of the money power, naively, unwittingly succored, are led along and drawn into such confidence games by the pitchman's lure of getting something for nothing, i.e. acquiring wealth without exchanging labor, a philosophical concept glorified by the same arch-charlatan racketeer who contrived these and other financial schemes, as well as the judicial and taxation industries. Over time, the end result of such perfidy is the same story: loss of wealth and freedom by the numerous individual players, and ever-increasing acquisitions of wealth and political power by the money-mongers that created, owned, and operated the game. This tiny tribe of gold worshippers successfully corrupted, embezzled the gold of, and fiscally conquered every great civilization in history: Babylon, Byzantium, Egypt, Rome, the British Empire. The crown is a straw man for the chosen masters. And now America, in the exact same way, from within, without military force. So we won the war militarily, but lost it through paperwork and money. Because it is basically inconceivable for average folks that any civilized group of men could be motivated by such absolute unbridled hatred for all non-cult members. These covert modern-day white-collar barbarians as a whole have gone unchecked over the millennia, save the periodic provincial expulsion for an unspeakable, abominable, ungodly, psychopathic practice, which will not be discussed here, still rampant today, but highly insulated and ultra-secret. The entire existence of this societas criminis, so criminal society, whose leaders claim a divine right to own everything in existence, is dedicated in furthering the ultimate cause of complete political and commercial enslavement of all outsiders and liquidation of any who do not willingly hop on the treadmill. Examine the blueprint and career of any communist country, and you will see that the chosen masters have planned for America and the world as communism is the quintessential embodiment and manifestation of their psychosis. Okay, let's read this part real quick. We have not begun to appreciate the depth of our guilt. We are intruders, we are subverters. We have taken your natural world, your ideals, your destiny, and played havoc with them. We have been at the bottom of not merely the latest Great War, but of every other major revolution in your history. We have brought discord and confusion and frustration into your personal and public life. We are still doing it. No one can tell how long we shall go on doing it. Who knows what great and glorious destiny might have been yours if we had left you alone. Marcellus L.E. Ravage, Century Magazine, February 1926. Your authors have a close friend of many years who has personally sat in at the highest levels of the banking world, where real-time display of all stock quotations and all exchanges worldwide can be viewed in a single room, where insiders may freely, simultaneously buy, sell identical securities in different markets and realize the difference in prices, generally an illegal practice known as arbitrage. arbitrage. Despite the dominance of such institutions throughout the world, all are dwarfed in sophistication by the electronic tentacled pseudo-government, private military unit, Department of the Treasury, IRS Securities and Exchange Commission, Bureau of Alcohol, Tobacco and Firearms, U.S. Secret Service, Bureau of the Public Debt, Financial Crimes Enforcement Network, FinCENS. The enforces global control over the flow of all Federal Reserve notes. Note, for non-karmic enthusiasts engaged in such occupations, there is no such thing as a free lunch. Psychopathic, socius, companion, Greek, pathy, disease of or relating to an antisocial personality disorder. Okay, here we go. Let's continue on. Factually, communist philosophy is now official policy of the U.S. government. The ownership of all property is in the state. Individual so-called ownership is only by virtue of the government. That is to say, law amounting to mere user and use must be accordance with law and subordinate to the necessities of the state. Senate Document 43, 73rd Congress, First Session. See entry by the same name in glossary. A possible origin of the U.S. Senate's communist stance on the issue of private ownership of property of Bernard Baruch, 1870 through 1965, Wall Street Mongol and American presidential economic advisor for more than 40 years. He has said, quote, "We are living in a highly organized state of socialism. The state is all. The individual is of importance only as he contributes to the welfare of the state. His property is only his as the state does not need it. He must hold his life and his possessions at the call of the state." Mr. Baruch's philosophy, of course, does not apply in the case of the incredible fortunes amassed by him and his fellow communist billionaire comrades, only the property of the little people. Next section, your future. By definition of the Uniform Commercial Code, by definition, the UCC encompasses all codified statutory law in existence governing all intercourse between and amongst all people, businesses and governments, as well as the issue of all currency, money, the single most important commodity in modern society. The master merchants that developed the UCC are fixated on enslavement, extermination of all outsiders by legal, commercial, military, i.e. admiralty. That's what admiralty means. The sooner you realize the dead seriousness of your would-be self-appointed slave master executioner and face facts of how the world goes around, the better chance you will have of avoiding victimization at their hands and enjoying your life. Once people stop agreeing and stop volunteering into commercial subjugation, the holy masters will have some serious problems on their hands. As they compromise only a minute segment of the population, hence the need for all the underdog hate crime legislation which they originated and authored, institute through their lackeys in D.C. and elsewhere. Their influence can be rather easily offset once large numbers of people catch on. The Crown and the U.S. government are bankrupt front operations for these miscreants, propped up for no other reason than to bilk and politically, militarily subjugate any and all who mistakenly do business with either. Despite the best laid plans of your self-appointed overlords, however, the current predicament is now rather easily remedied. The name of the game is commerce. Contracts, revealed and unrevealed, accounting, debits, credits, etc., commercial machinery is triggered by unwittingly and voluntarily contracting with private governmental corporations long since bankrupt and now only shams of Federal Reserve creditors. Shams for Federal Reserve creditors. Consensual contracts are enforced both judicially via the legal system and privately non-judicial system via the prescriptions of the UCC. When you make a self-determined decision to do business with a corporate government, you will invariably suffer the consequences. In America, the notion of freedom extends no further than the right to contract with whomever you wish, and the right not to contract with those you do not. Once a trusting citizen enters a contract with bankrupt government, however, he becomes a fiscal subject, economic slave, and all other freedoms become distant memories. The only thing impeding your survival is your grasp of the essence of the basic terms used to describe any commercial relationship and the rules of commerce as embodied in the Uniform Commercial Code. For the owners of all the currencies of the world, the UCC is the only game in town, eclipsing and engulfing all others. See UCC 1-103. Ignore it at your peril. Heed its tenets for your betterment. Fortunately for all, a few sturdy souls have deciphered the key issues and principal factors for redemptors and have charted the route through the UCC and revised Article 9, and made it out the other side. Something can be done, and that is arming oneself with the same kind of ammo being used against one, the silver bullets of the Articles of the Uniform Commercial Code. The first step is copyrighting your all-capital trade name under the common law as described in detail in the practical section of this manual. No one in the legal system government, including any esquire of any statute at any level, has any right to use your common law copyrighted property for commercial gain without compensating you, and no law exists that will support such piracy. Those who foolishly believe that they are above the law and are untouchable by the little people will quickly discover the dead seriousness of the consequences of dealing with someone who understands the key elements of the Uniform Commercial Code and how to enforce them. The objective of this article is to help the student of the law with an understanding of the actual nature of the legal system so he or she is not tripped up believing the propaganda issuing therefrom and trusting the juristic disassemblers that specializes in crushing dreams and destroying lives. Learn and use the selfsame weapon of choice of those who would confiscate the very air you breathe if they could, the Uniform Commercial Code, and afford yourself the best chance of prevailing over pernicious esquires and organized criminal syndicate that invented them. Looks like it for now. Next stop is Section 3, the curse of co-suretyship, and why you're held accountable for the national debt. Thanks for listening.